Hello and good evening and welcome to another episode of Law and Order. And this week, like every week, we take a topic on law which is important to you and get in our studio an expert and talk on that topic to inform you. Now today, our area is called Maritime Law and Law of the Sea, which is a very rarely spoken subject, and we have very few experts on that as well. This is important to anybody who is dealing with sea or shipping or in any of those areas, and to the public as well, for you to know what exactly law of the sea means, because sometimes you might need it. So my guest today is an expert on the maritime law. He has a PhD from University of Hamburg, Germany on maritime law. He is Dan Malika Gunasekera. He is also an executive director of the Ceylon Shipping Corporation Limited. Malika, thank you very much for joining us. And how are you keeping today?
Thank you very much for inviting me, and it's very nice to be here.
It's a pleasure. Now, tell me, let's start off before we go to the issues. We have a lot of things to talk about on this area. What is, in simple terms, law of the sea or maritime law? Or are they two different things?
Yes, I think if we open this discussion by understanding the fact that likewise the land, sea also needs to have rules and regulations, especially for the users of the sea. And when it comes to users of the sea, it's not only the states but also the ships and other elements that use the sea and oceans at large. Now, law of the sea is mainly the law relating to oceans and the seas at public law aspect, where it is the states in the world, whether they are coastal or landlocked, have entered into certain rights and obligations for the fulfillment of the users of the sea. But when it comes to maritime law, it is an area where the users of the sea, especially ships and other crafts that uses the sea and oceans, need to undergo and observe the rules and regulations set forth for the use of the sea. So now, maritime law is a private law aspect, different from the law of the sea, as I told you, which is a public law aspect. Now, if you look at these two subjects, we in Sri Lanka see that they are very developing and they are very new to us. But in the world and in the history, these are not new subjects. There have been developments of this area, introduction of law of the sea way back in the history, where maritime superpowers such as Portuguese, Dutch, English, Spain of yesteryear, they used to consider this area as a very important subject for them to traverse along the sea routes and the oceans, especially with the introduction of the freedom of navigation in the sea by the international law jurists of yesteryears called Hugo Grotius, a Dutch lawyer who served as the legal consultant for East Indies Company, called that the freedom of navigation is very important for states to go around the world, and that is how they even came to Sri Lanka and colonized this country.
Now, ship docking in for this island is not a strange thing. As you know, for the past 2,500 years from the arrival of King Vijaya, everybody is somebody who came in a ship, and the Dutch and the Portuguese and the Brits and everything. So, but so the shipping is a very, very known thing to any island, for that matter, of Sri Lanka. My question to you is now, international law of the sea, how does it relevant to any country for that matter, and how does it relevant to here? And my second question, if I may couple this with this, is what is the local pieces of legislatures that coincide with this? Yeah,
I think you have given me a good question to open up this discussion in a very helpful manner for the public at large. Basically, a law of the sea started way back in 1958 with the introduction of certain international conventions by states in The Hague, called the Hague Conference, where they introduced 4 pieces of legislations, especially dealing with the territorial sea, the contiguous zone, and so forth. But these conventions tend to limit the uses of the sea to a certain extent for the states, especially bordering the important sea lanes in the world, unlike for the landlocked states. They considered that these conventions might try to narrow down their rights and privileges in the waters around them. So that is why most of the countries did not like to adopt these conventions. Now, one of the aspects is that we as a maritime or as a island nation, sea is very important for us because it surrounds the entire country. So therefore, our land territory conquers another portion of the sea area, which is called the territorial sea, extending to about 12 nautical miles as far as we can extend. And in that particular territorial sea, the law of this land also applies equally to the sea area of this territorial sea. So the countries at that time did not want to curtail their rights, especially with this area of territorial sea, that introduced a territorial sea belt of about 3 nautical miles, which the countries considered that it's not enough. So these discussions went on until in late 1960s. The United Nations Conference on Law of the Sea was convened. And it was convened firstly as UNCLOS 1, but it was not a success, since there were a lot of deliberations in these conferences by different states that there are legal areas that most of the countries cannot agree upon. So they went into the second conference called the UNCLOS 2, but also they could not agree to one-piece legislation. But UNCLOS 3 became a success. Actually, I would like to say that it was due to a very mammoth effort of a Sri Lankan, who was the Sri Lankan ambassador to the UN at that time, late Mr. Shirley Amarasinghe. He articulated this Law of the Sea Convention, and finally it was signed in 1982 in Montego Bay. And Sri Lanka became a party to the UNCLOS 3, or the United Nations Convention on Law of the Sea, in 1994. And since then, the United Nations Convention is applicable in Sri Lanka. But as a dualistic state, we need to have the local legislation in law. So for that, we have this corresponding, different corresponding statutes, starting with the Maritime Zones Act, for example, that defines the Sri Lankans' entitlement to the sea. So this is the start, and from the international convention with regard to different subjects and areas, there are plenty of national laws that have been implemented or enacted in this country, and in various service sectors. These legislations do play a huge role.
Right. Now, let me ask a sub-question, maybe on the borders, on the boundary levels. You said about the 25 miles and all that. Wasn't there a move by international, something to do with the United Nations arm that deals with sea and the demarcations, to redemarcate certain areas of the sea? What a country would own? Wasn't there a move like that a few years ago?
Yes. I mean,
what happened with that?
Yeah, I think you are referring to the continental shelf margin.
Right.
Right. Now, if you look at the different maritime zones for a country by law, any country, any coastal state can have a maximum of 12 nautical miles. But when you look at Sri Lanka, for example, in certain areas we can't go to this maximum entitlement of 12 nautical miles, especially considering the north, where we have the Adams Bridge between Mannar and Talemanar and Rameswaram. The particular sea stretch is only about 80 nautical miles in total, which means that if we go for an equal distribution, Sri Lanka will have 9 and India will have 9. So neither country can go up to that 12 nautical miles. But in other areas,
what did we do on that situation?
What we do is a good question. There are two ways of delimiting the maritime boundaries. One way is by applying the equidistance rule. Under the Law of the Sea Convention. If you apply the equidistance rule, then you divide the maritime zones equally among the two states, opposing states. But equidistance rule is not always applicable in all parts of the world, because there may be sometimes some disadvantaged areas in the sea for certain countries, and for the opposing states to have certain advantaged areas. Now, for example, if there are two oppositive states where the sea area is more deeper for one country and more shallow for the other country, if you go on the equidistance principle, one country is getting a disadvantaged situation. So for that, the law has, or the international community in preparing this piece of legislation, have also viewed at developing the equitable principle, where depending on the resources and the use of the sea for different countries, you go on the basis of equitably delimiting the sea areas. Now, if I come back to what I said before on the continental shelf margin, which is a very recently debated subject, the Law of the Sea Convention provides underneath the sea, any country can claim for a sea area or extending to a 200 nautical miles continental shelf, where the margin ends at 200 basically. But depending on the structure of the sediment rocks and so forth underneath the sea, there is a further extension granted by Law of the Sea Convention about 100 nautical miles. But under the amendment, the first amendment, what we call the protocol of the Law of the Sea Convention, they gave several certain countries with disadvantaged sea area or the coast to go more even beyond these 350 nautical miles up to even 450 nautical miles if their continental shelf could support the idea of extension of the natural prolongation of the land territory.
Okay. Malika, now this administering of ocean and maritime related activities, is there a particular body which does that in Sri Lanka?
That's a good question. I think you may be referring to a regulatory body. Now we know in the telecom sector
we have TRC.
But in the maritime and the law ocean sector, there is no one particular institution. If you look at the sea as a whole around Sri Lanka and with the entitlement of our maritime borders, it is actually the foreign ministry that has the power to deal with this matter, and also with the assistance of Ministry of Justice. And then we have several institutions like for example, we have the MIPA, the Marine Environment Protection Committee for the protection of marine environment.
If I may butt in, isn't it time that we have one regulatory body? Isn't it the same? Isn't it like that in other countries?
Actually it is, because some countries do have one particular regulatory body. But in Sri Lanka, I think it's a very bureaucratic obstacle that has come into this area. It's very difficult to have one particular regulatory body.
But if we start that, it can encompass all these things and give necessary powers to carry out, right?
I think so, because what we have to do
is possible in other countries, it's possible here.
Definitely, because what I feel is that we can have one regulatory body and subordinate the different subjects
Yes.
to other departments and various governmental organizations.
Right.
Now, if I go back to the maritime sector,
Yeah.
shipping, the regulatory body is the Director General of Maritime Shipping.
Yes.
He is called the Port State Controller
Right.
and the Coastal State Controller,
Yes.
Flag State Controller.
Yeah.
So, there are these areas, but also if you take MIPA for example, MIPA is also a coastal state controller where it has several important powers to control and prevent the marine pollution.
Yes. Why I ask you that was because let me ask you a little bit of a controversial issue which was doing its circles in media and courts and all over, the floating armory issue which came up last year.
Yes.
Now, can you tell me, basically, first of all, let me ask you, was that legal, the floating armory thing?
Floating armory is legal because we see that it's not only in our country where we have to face these situations of a floating armory. Actually, floating armory started in other developed countries,
right,
especially to deal with the piracy matters. We know that in the history we used to have pirates of the Caribbean.
Yes.
Then we used to have pirates of Malacca Straits.
Yes.
And but now the biggest problem is with the pirates of Somalia.
Yes.
Now with these developments in the security system, especially piracy and terrorism, we need to have ships guarded with armory in order to protect the cargo, the ship and the personnel on board. And so for that we need to have arms on board. Now in England for example, they openly give licenses called I think the open general licenses for these armories. So armories in itself is not illegal, but there are certain procedures that you need to follow in obtaining the permission to operate a particular armory. Now that is where certain armories could go illegal and certain armories could go legal, because as long as you fulfill the